Hi, I'm Jay Norton, DUI attorney in Kansas. And I want to talk to you about the first thing you need to know when you are facing a DUI case in Kansas. And that is when you get arrested for a DUI and you either take a test and fail it or you refuse that test, you get two different cases going on at the same time. The first is the criminal case that's filed against you where you're charged with a DUI and whatever else they may have charged you with. But at the same time, you've got an administrative action against your driver's license, which is represented by a form that the officer should have given you. Sometimes it's pink, sometimes it's white. That form at the top says officer's certification and notice of suspension. And down in the bottom left-hand corner, it'll say DC 27. The DC 27, that stands for driver control 27, that form is a temporary driver's license. And the law enforcement officer will take your physical driver's license and give you that temporary driver's license for you to drive on. And that officer certification and notice of suspension, that form, like I said, sometimes it's pink, sometimes it's white. That is your driver's license, and it contains all of the same, rights and privileges that you had in your driver's license before you were arrested. But it's a temporary driver's license. It tells you that it's only good for 30 days. And after 30 days, then your driver's license would be suspended and then restricted to an ignition airlock device based on whatever the officer has certified, that you failed a test or that you refused a test. It's real important, though, that you know that in the fine print, it tells you that you can request a hearing about whether your license should be suspended. You have to request that hearing within 14 days. So the first thing that I do when somebody hires me on a DUI case is I request the administrative hearing on their behalf. I do that in writing, and I send that to the Department of Revenue certified, return receipt requested, so I can prove that they got it, when they got it, and who signed for it. I also fax it and get a fax confirmation back so that we have redundant processes to prove that they received the request for the administrative hearing. Once we do that, then your driver's license is going to remain valid until we can have a hearing about whether it should be suspended or not. And that hearing is typically 2 or 3 months down the road, 2 or 3 months from when you request the administrative hearing or when you get stopped for a DUI. And between requesting the hearing and that actual hearing date, 2 or 3 months later, I can get all the police reports, the video recordings, the audio recordings, every scrap of evidence that there is on the case, the photographs, diagrams, witness statements, accident reports, whatever there may be. We get all of that information. I get all the information on the breath test machine, maintenance logs, calibration logs, testing logs. We want to get every single piece of evidence that we can so that all that can be reviewed prior to having the administrative hearing. The videos, of course, are the most important. So we got to watch the videos before the administrative hearing. When you request the administrative hearing, you have to request an in-person hearing, or else all you get is a telephone hearing. I like to have an in-person hearing. I want to have the officer show up. I want to put them under oath. I want to cross-examine them, in their presence. I want to see how they testify. I want to look in their eyes, really get a sense of what their attitude is, what their testimony is going to be, how it's going to play out in court should this case proceed to a trial or something down the road. If there's any issues that you have discovered, that's a good time to question about them and, hopefully get information that you can use in the administrative hearing and in the criminal case. You've got to ask for a subpoena of the officer or officers that signed that form. Or else they won't come. And if they aren't subpoenaed and they don't come to the hearing, then you can't raise the issues, all the issues that you want to raise. You have the burden of proof at the administrative hearing, so you've got to bring the evidence. And the only witness you can have really is the arresting officer. So you got to request a subpoena of the officer. You got to request an in-person hearing. If you do that, like I said, they'll set up a hearing about 2 or 3 months down the road. Those hearings are only scheduled to last about 15 minutes. So they're not, full day in court type hearings. They're quick little lightning rounds. And so you got to get prepared to show up to that hearing, be ready to go and have your issues, that you want to try to bring up and hit them with everything that you got, quickly and efficiently. Um, the driver's license hearings in Johnson County are held in the Johnson County Administrative Building, or if it's an Overland Park case, they're held in the Overland Park Police Department, the old one at 85th and Antioch. In Wyandotte County, they have them in the Wyandotte County District Courthouse. In Douglas County, they do them in the DMV there in North Lawrence. Each different county or jurisdiction has some government building where they have these administrative hearings, and it's just the administrative hearing officer plus me and the arresting officer typically. My clients don't have to show up to that. You don't have to be there for the administrative hearing if you have an attorney that's going to handle it for you. Some people want to be at the hearing. That's perfectly fine. It's open to the public. It's their hearing, and they have every right to be there. But I can handle that on behalf of my clients. You don't have to be there. The only time I have my clients show up to the driver's license hearing is if there's something that I need you to testify to. We have the burden of proof, like I said. So if there's something that only my client can testify to, that's the only way to get that evidence in, then I need to have my client show up. So things like whether they were driving the car or whether they had, something in their mouth or they belched prior to the breath test or some issue like that only they can testify to, that's when I have my client show up. But in the majority of cases, it's something that I do on your behalf. And, the administrative hearing, like I said, is not, a full hearing. It's not like you're going to get in a criminal case. They set these things up to try to take people's driver's licenses away, basically. So, in a criminal case, you're presumed innocent and the government has the burden of proof, and they got to prove you guilty beyond a reasonable doubt. And you have all kinds of defenses and constitutional rights that you can invoke to try to, prevent that from happening. So because they know that people can, fight and win DUI cases in the criminal courts, they set up this parallel universe where, because driving is a privilege and not a right, it can be taken away by the government with less pomp and circumstance, less process than other rights can be taken away because it's not a right, it's a privilege. And so they set up this civil administrative action where you're presumed guilty when the officer fills out that form properly, that officer's certification and notice of suspension. You have the burden of proof. You've got to come in and prove that the things that he or she has certified in that form are false or insufficient. And there's a limited number of issues that you can raise, and you don't have all the constitutional rights that you would have like in a criminal case. So the administrative hearings can be difficult, and a lot of attorneys don't bother with them. A lot of attorneys encourage their clients to just go ahead and eat the suspension. I never do that. I fight every single one of them. We want to go in there and have our day in court with respect to people's driver's licenses. That issue is important. And so I always think it's worth it to show up and at least, raise the issues that you can. And it's also important to see how the officer is going to testify, to know, if that may be helpful or useful in the criminal case. So I always have that hearing, and, we do the best we can, and, we can't win them all, but can win a fair number of those by getting prepared and knowing the law and showing up and hitting them with everything that you've got. At the end of the hearing officer really has three different options. They can affirm the suspension of the driving privileges, which means that your license is going to get suspended and or restricted. They can dismiss the proceedings against the license, which means you're not going to get suspended and you're not going to get restricted as a result of the administrative hearing. Or they can take it under advisement, which means that they want to go back to their office and review a video, look at the law, consider further, the arguments that were raised at the hearing. And then you get a decision back sometime, a month or two later. If you lose the administrative hearing, then your license will be suspended beginning 30 days after the date of the hearing. So if you have that hearing on April 15th and you lose, then May 15th, your driver's license is going to get suspended. How long it gets suspended and restricted for depends on whether you have a prior DUI in your lifetime in the state of Kansas, or if, and it depends on whether you took the breath test, blood test, or refused it, and what your alcohol content was. So if you've never had a DUI before, you take a breath test and it's between a 0.08 and a 0.15, then it's a 30-day suspension followed by 6 months of ignition interlock device. If you were over a 0.15 on a first-time DUI, it's a 1-year suspension followed by 1 year of restriction to an ignition interlock device. If you refuse a test, then it's a 1-year suspension followed by 2 years of restriction to an ignition interlock device. So it's a 3-year transaction on your driver's license for a first-time refusal of a test. If you have a prior, then the length of restriction can be longer, and it can be 5 years and 10 years and on up, depending on how many prior DUI occurrences you have on your driving record in your lifetime. The good news is that under fairly recent changes to Kansas law, if your driver's license gets suspended, you can file an application with the Kansas Department of Revenue to have the suspension modified to a restriction to the ignition interlock device. So if you get a 30-day suspension or you get a 1-year suspension, you can file this application and you will not have to be suspended. You can drive during that time period with the ignition interlock device. So the application to have your suspension modified to a restriction is called a DC 1015, DC 1015. You can get that form at the Kansas Department of Revenue's website. You can get it on my website. You can find it out there. It's a very simple form, and I'm going to show that to you. Suspended. If you want to show you the DC 1015, that is the application to modify an alcohol-related suspension or revocation. So if your driver's license gets suspended, you can submit this application and the Department of Revenue will grant it as long as you're not suspended for some other reason. It's a real simple form. All you have to do is print your name and your driver's license number, date of birth, your address in there. It asks you here, have you operated a vehicle while you were suspended or revoked? This really only applies to suspensions that occurred before 2011, but hopefully the answer to this is no anyway. And you sign it, you date it, and you just take this form and you mail it to the Kansas Department of Revenue with $100. Of course, there is a fee associated with it. It's $100, but you've got to send this in. The address is down here at the bottom, Division of Vehicles, Driver Solutions in Topeka. You send that in with $100. They will grant it as long as you're not suspended for some other reason. Hopefully, shortly after you file the application, they will review it. They'll send you a letter and tells you that you can drive. Again, this is the DC 1015 that you can get from the Kansas Department of Revenue, and if your license gets suspended, you might want to submit that so that you can drive with an interlock instead of being suspended. The Department of Revenue has to grant that application, and as long as you're not suspended for some other reason, they will grant that and they will allow you to drive. They will not consider that application until the 30th day after the hearing, or once the suspension is supposed to start, then they will consider the application. So there might be a day or two or a few days where you can't legally drive, but you should shortly thereafter get a letter from the Department of Revenue that says, we've granted your application to modify the suspension. You can go get an ignition interlock device put in your car, and you can drive with the ignition interlock device. And when you're under an ignition interlock device restriction, you can drive anywhere you want to, whenever you want to, for whatever reason. You're not restricted to and from work or anything like that. You can drive anywhere, anytime, any place, but you have to have the ignition interlock device in your car. The ignition interlock device is a device, a gizmo, that's wired into your ignition, and you've got to blow into it in order to start the car. And you've got to blow into it from time to time, every 15, 20 minutes or so, to keep the car running. And if you have alcohol on your breath, then the car won't start, and the car won't keep running if you blow numbers. So it makes sure that you're not drinking and driving when you have the ignition interlock device in your car. It costs $150 to have the interlock put in your car. Typically, it costs around $80 a month to rent it from the ignition interlock company, and you got to take the car in every month to have the digital information downloaded from the interlock by the company and to prove that you still have it and it's still in working condition and all that. But you can drive, and it's better than being suspended. And so there's a decent chance that you're going to have an ignition interlock device in your car. You can drive any car that you want, but it's got to have an ignition interlock device in it. And anybody in your family can drive your car with the interlock device, but they're going to have to blow into it in order to start it. So the important things to know right from the outset is that you've got 14 days to request an administrative hearing. You need to ask for an in-person hearing if you want one. You need to ask for a subpoena of the officer, or else you won't get one. I highly suggest that you have an attorney do that for you. It's got to be done in writing. It's got to be sent to the Department of Revenue certified, return receipt requested. That way you can prove that they got it. And then your license is going to be valid until you can have a hearing, and you'll have a shot to try to keep your license from being suspended.